Okay, so welcome to the podcast entitled Co-ownership Termination. This podcast will go for about 15 minutes. In the recording, we're going to be talking about how a co-ownership arrangement can be brought to an end, either as agreed between the parties, or if one co-owner doesn't agree, then what the other one can do to force them to end the co-ownership and or sell the property. So let's get started. This is the key question we're talking about now. How can co-ownership be brought to an end? Previous podcasts we've talked about what co-ownership is, the differences between joint tenants and tenants in common. In the second podcast we talked about the rights and obligations between co-owners. So you might recall we were talking about things like whether an occupation rent has to be paid if a person is not if the co-owner is not in possession of the premises, whether somebody can claim money for improvements that they've done. What else did we discuss? Oh, that's right, the rights for bringing somebody else onto the property, i.e. a stranger, or creating a lease, or some other type of possessory arrangement. And this particular recording, we're going to talk about, okay, well, once we know how it's created, what the rights and obligations are, how can we bring it to an end? So essentially, what we're talking about, there are two, I guess, concepts here. One is where we have a joint tenancy, and we're talking about severing that joint tenancy, i.e. cutting it off, and turning it into a tenancy in common. So that'll be important. We can think about practically, for some reasons, if there's a couple and they don't particularly want to hold anymore as joint tenants, how can they then separate that interest and turn it into a tenancy in common? The other issue is whether we've got a tenancy in common or a joint tenancy, and how we can actually bring that whole co-ownership arrangement to an end. So the two, I guess, separate concepts we're talking about there. The first and best way, I guess, to get rid of a co-ownership arrangement is to have all the parties, two or more of the parties, agree that they're going to transfer their interest to a third party, or indeed two or more of them are going to transfer it to the remaining co-owner. So what that'll do is essentially break the unity of title that they all hold and allow the new owner to become the owner without any form of co-ownership arrangement. So that can occur provided all parties are on good terms and happy to do that as such. Of course, they can sell it to another two people who will then come in and take the property as co-owners, but in a different set of co-ownership arrangements. So for example, if my partner and I decided to sell our property to a third party, that third party was another couple, then our co-ownership would end and theirs would begin. In terms of other ways in which a co-ownership can come to an end, if we have, in the case of a joint tenancy, we have a tenant, one of the tenants dies, then the other one, there's only one other joint tenant, then that one will inherit according to the right of survivorship. But they'll then have an entire right to the property, and there'll be effectively no co-ownership because we've only got one owner. When we were talking about, there's also an option for a court order. So we'll talk about later in this podcast how one co-owner can actually apply to the court to appoint a trustee to sell the property if the other person doesn't want to sell it. Right, and in cases of severing the actual joint tenancy, and that is turning the joint tenancy into a tenancy in common, there are four ways in which that can be done. So here's that situation of termination of a co-ownership I was talking about, where there's an agreement by all three co-owners to transfer their communal interest to a third party. That will basically destroy the co-ownership arrangement. Or you can have a situation where two of the co-owners decide to transfer their interest to a remaining co-owner, in the case of three co-owners. Of course, if there were more co-owners, then they will have to, I guess, transfer their interest to the remaining co-owner. In such a case, money is likely to exchange hands, and the property will then be owned by one person and not more than one, and therefore there will be, in fact, no co-ownership in place. So here we're talking about the situation of where a joint tenancy, that is co-ownership of a property owned by two or more people, where there is not a distinct share or distinct identifiable proportion or fraction of ownership, because that would be a tenancy in common situation, but where there is a joint tenancy situation, and how we can sever that joint tenancy or cut it or otherwise transform it from being a joint tenancy into a tenant in common situation. So there are three basic ways in which that can be done, set out in William van Hensman, 1861 case. The first is that an act of the person doing something with their share to create a sentence. So, for example, transferring their interest to somebody else. Secondly, it might also be the case of mutual agreement between all three parties, that they're going to come to a conclusion that they're going to sell the entire property to a third party, or that they're then going to not hold anymore as joint tenants, but hold as tenants in common. And the third way, is probably the way that causes a lot of confusion, is by course of dealing. So them doing something with the property that will actually give rise to the indication that the interests were to be severed from the joint tenancy. So this particular, the third way of doing it really creates some problems, because here you're dealing with factual circumstances as opposed to things they actually do through agreement and through clear documentation. So a good case of the third way is this High Court case. Not a good case, it's a good example of how, to what extent the court will recognise a severance of a joint tenancy through a course of dealing. So in this case, we had Mrs. Patton, who was very sick and about to die. She held a property joint tenancy with her husband, and she wanted to sever that joint tenancy before her death, so the property wouldn't automatically go to the husband on her death, and would be able to go according to her wishes through her will. So she had a solicitor come and visit, and they executed a transfer document and a declaration of trust. Unfortunately, the certificate of title was not obtained by the bank. So, was not obtained from the bank. So, well, there's a little bit of history here that you need to know, that once upon a time we had these old certificates of title, which were basically paper documents which showed someone's ownership over a piece of property. But today we have very few certificates of title, physical certificate of title in existence. But in those days, in the 1990s, and I believe this was the New South Wales case, where they still do have a lot of certificates of title, they had to actually obtain the paper copy and lodge that along with the transfer document, because the certificate of title showed that you had good title to the property, or you were about to get, you were purchasing good title to the property. In Queensland, it doesn't apply so much anymore, but this is why that factual scenario is relevant in this High Court case. The reason it was with the bank is because the bank was holding it as a way of security for the mortgage that they had given to Mrs. Patton. So there was a mortgage over the property, and in order to register the transfer, that is to bring the new person onto the property, in this case, to get out of the joint tenancy arrangement, they had to register this transfer document, and they had to lodge the certificate of title at the same time. Now, they didn't do that, and this was key in this case. And the court had to weigh up, well, not getting the certificate of title, does that mean that Mrs. Patton, through her solicitor, had done everything that she could have in the course of the dealing to actually sever the joint tenancy relationship that she had with her husband? And so what did the court say? Well, basically it's not enough to do unilateral actions such as this, to have a declaration of trust or to write it out in your own will, saying this is no longer a joint tenancy. you need to actually have positive action that sever the joint tenancy. And really, the court is saying here, well, we need to know that you have gone to everything, to all extent possible, to complete this transfer of your interest, to sever it from being a joint tenancy into a tenancy in common situation. In Queensland these days, a person can also sever a joint tenancy by registering a transfer. So this isn't available in all states, but it is in Queensland. So they can simply complete a transfer form and their interest will be severed. However, and turned into a tenancy in common. However, the registrar, that is the person looking after the registry, needs to be satisfied that reasonable attempts have been made to tell the other co-owners that this is what they're doing. Right, so the other way in which a co-ownership can come to an end, we found in the provisions of the Property Law Act, where a co-owner can, rather than trying to dispose of their share individually, might want to sell the entire property, or in some cases, apply to the court for petitioning of the property. And what that basically means is dividing up the property according to the proportions in which the co-owners hold the place. So you find it in these sections 37 through to 43 of the Property Law Act. The important ones that you probably need to know there are section 38 and all the way down to 43. So in section 38, a person that is a co-owner, whether they're a joint tenant or a tenant in common, can actually apply to the court for the appointment of trustees. So the appointment of a statutory trustee to basically sell the property on behalf of the co-owners and then account to them for their respective shares. So it's a way of getting out of the co-ownership arrangement where one person is in the co-ownership is potentially disagreeable to selling the property. We also have a different situation sometimes arising on facts where co-owners might agree between themselves that they can't sell the property. We call these rights of preemptions. So for example, I purchase a property with my business partner, we're co-owners, we do it as tenants in common, but then I say that we agree between each other that we will not sell this property for another 35 years. And that person cannot dispose of their interest in the property for 35 years. We might have some agreement like that. The question is, well, is that agreement valid? Can it actually be enforced in law? And the particular thing the courts have looked at over the years, both in Queensland and in other states, is, well, is this in some way ousting the jurisdiction of the court, or the ability of one co-owner to go to the court and to apply for a sale of the property within a particular time frame? So we have a case in Queensland called Permanent Trustee Nominees, 1989 case. Here we have an agreement whereas a separate and severable covenant, that is obligation, we'll come across that term later when we come to talk about leases. The parties agree that neither of them will sell the place, neither of them will make an application to that part of the Property Law Act, which I said before, without first giving the other party 12 months notice. So they're saying, look, we want a notice period here for each of us before we even try to sell this place. The question before the court was, well, was that agreement valid? The court held, well, this particular arrangement, where they had bought land, including a motel on the property, was not actually void. So it was allowable. It didn't oust the jurisdiction of the court, and it also didn't breach this important rule that there cannot be a restraint on alienation of a person's proprietary rights. So that's an important point which we'll come to in a second. So in Permanent Trustees, the decision of Kelly J said the effect of the agreement between the parties was not to oust the jurisdiction of the court, but merely to give a notice period before seeking to exercise that jurisdiction. So they're drawing a fine distinction between a notice period to exercise the right to sell and removing the right to sell altogether. Again, Kelly goes on, there is nothing in the terms of section 38 which could infer that the parties agreed that neither would seek to exercise the statutory right without giving even a period as long as 12 months is prohibited, and it is difficult to see any public interest in prohibiting such a covenant. So here you've got the court saying, look, we're only really going to look into these if there's some public interest problem that's going on here. The decision of Justice Connolly was the same, but for a slightly different reasoning. For my part, I cannot see that Clause 6 of the Management Agreement affects the slightest degree to abrogate the jurisdiction of the court. So in other words, Justice Connolly is saying the same thing. This is no more than a mutual promise not to exercise a right, save for a period of notice. So again, the court here is saying, look, there's a difference between us having a period of notice for the sale of a co-owned property and a provision in an agreement which says under no circumstances shall a co-owner apply to the court to sell the property. As quickly mentioned before, and you'll go through this again in your tutorials, there is a principle of the law that you cannot restrict the alienation of a fee simple estate. So eventually that means that you cannot say to someone, yes, you own it, but you can in no way sell it or do anything with it. That would be seen as being void against public policy. So you've got Dixon in this 1960 High Court case, very important case, I encourage you to read, particularly for the tutorial for this week, saying the ground for denying the validity of a contractual restriction upon alienation is that it is the principle of law that private property should be fully alienable. A contractual restriction upon the alienation of an absolute estate is if unqualified, should be considered void. This seems to accord with the modern views of policy. So there cannot be a contract between the two which says to, for example, one party, under no circumstances are you allowed to sell our property or transfer your interest in the property. So that's it. Just to recap, we had a quick discussion at the start talking about the difference between severance of a joint tenancy, which will effectively turn it into a tenancy in common. That could be done through several ways, including through mutual agreement by registering a transfer under Section 59 of the Land Title Act, and through course of dealing. But note the restrictions that the court said in Corrin and Patton, that they have to do something which is, they have to do everything that is necessary, basically, to effect the transfer of the interest. In that case, Mrs. Patton didn't actually go and get the certificate of title, which was still held at the bank, and therefore the severance never occurred. Then we also talked about the right of a co-owner to apply to the court under the Property Law Act, Section 38, and that person needs to always have that right, and you cannot oust the jurisdiction of the court or prevent unreasonably a person's right to alienate their proprietary interests. And that comes from that High Court case of Holland-Dorst in 1960. Otherwise, just having a mere notice period will be sufficient, as you saw from the permanent trustees case. So you might think of other circumstances that indeed we'll be dealing with more in the tutorial around those agreements between co-owners.